part-heard appeals in the matter of the Retirement, Saving and Welfare Fund of Oil Industry Workers and Crescent Gas Corporation Limited and another.
Yes, Mr. Hello, my lady, good morning. I was going to turn to Section 53(1)(b) and its application to companies. Now, the appellant's argument here, put shortly, is that Section 53(1)(b) must have been intended to apply to agents because companies can only act through agents. Now, the short answer to the point is that there is a fundamental distinction in law between a document being signed by a company and a document being signed on behalf of a company by its agent. So, of course, companies are well able to comply with the subsection by providing evidence that when the company has declared a trust or made a transfer on trust, and the requirements of the section are not onerous. Now, where a company settler is providing proof for the purposes of the section, it will have to comply with the prevailing law as to what constitutes signature by the company. Now, this issue is of some importance to ground 2 as well, so it's a convenient bridge between the two grounds. The history was explained in the Hilme case, which is in Authorities Bundle 2, tab 58. (1168). Authorities Bundle 2, tab 58 in the Court of Appeal 2010. This case again concerned a notice under the 1993 Act, the Leasehold Reform and Housing and Urban Development Act, which, as we saw by its section 99(5)(a), had to be signed by the tenant. And we saw that section drawing a distinction between notices to be signed by and notices which could be signed on behalf of the tenant. The legislation is quoted by Lord Justice Lloyd at paragraph 3 on page 3 of this report. Now, and at paragraph 4, you'll see at the foot of the page, Lord Justice Lloyd refers to the St. Ermines and the Cascades cases, which construction the court in this case obviously followed. And in paragraph 5, they, over the page 4, they refer to the issue they had, which is two conflicting decisions below about whether, in the case of a corporate tenant, the signature of one director was sufficient. That's the issue identified in 5. And down the page, in fact, only a little bit down the page, Lord Justice Lloyd from paragraph 7 explains the history of the legislation in this area. It's now found in section 44 of the Companies Act 2006, by the way. But the legislation at the time of the notice relevant to the Hilme case was contained in amendments made in 1989 and 2005, which introduced into the 1985 Act a new section 36A. And in the Companies Act, there are, just to be clear, there are provisions relating to companies signing contracts, there are provisions relating to deeds, and there are provisions relating to the execution of documents now in the Act. And Lord Justice Lloyd, paragraph 10 at the foot of the page, he cites the relevant section 36A at the time, which we see over the page at page 5, provided for the company to execute either by seal, that's it, 36, it was 36A12, or signed by a director and secretary or two directors, and that's at sub 4 there. And deeds at the time were governed by section 36AA. Now, I would ask your lordships, my lady, to note from this decision that the court refers in paragraph 17 on page 6 of the bundle to the limited authority on how a company signs a document other than a contract. And his lordship noted in that paragraph that statutes requiring personal signature were unusual, but he regarded section 53(1)(b) as one of those statutes. And he observes there that it was likely that if a company declared a trust of land, it was likely it would use a deed, and that in prior times the use of corporate seal was more frequent. And in either case, no issue was likely to arise. And so he's as he uses the word speculate, he's speculating as to why there isn't more authority on it. And paragraph 17 also proceeds again on the obiter view that section 53(1)(b) requires signature by the company. Now, it also and it also supports the notion that companies would ordinarily execute these kinds of documents with a degree of formality, and the learned judge doesn't seem to regard it as being difficult for corporate settlers to comply with such formality. Now, the argument was considered in Hilmy that a company can only act through agents, because that was the reason why Judge Reed in the court below, in one of the conflicting decisions, had decided that one director's signature was sufficient. That's back on paragraph 14, on page 6 of the report. I won't quote, he quotes from Judge Reed's judgment, but just beside the letter C, he basically referred in his judgment to a company being an artificial person can only act through agents. And the Court of Appeal obviously disagreed with that interpretation. They rejected also an argument that section 36A did not apply to all documents signed by companies, leaving aside contracts and deeds, but just documents requiring some degree of formality. That was argued, and that was rejected on page 9 of the report, page 9, bundle page 9 of the report, in paragraph 26 to 26. That you can see that being argued, that there was a distinction with documents which require a degree of formality. Well, that was rejected in the passage that follows. And the court found unanimously at page 10 in the bundle on the report, paragraph 31, that section 36A did prescribe how a company could sign a document which was required for some formal legal purpose. That's the finding in paragraph 31. And therefore, a document signed by one director only was not enough because it did not comply. Now, as I mentioned,
it's paragraph 32 is really the nub of it, isn't it? Because what he's saying there is he poses the example of the company's solicitor.
yes,
If it was simply enough to be signed on behalf of the company, then authorising the company's solicitor to sign on behalf of the company wouldn't be sufficient.
yes.
But that's not what what they're saying here. That's not what the statute says. to buy, not on behalf of. And he makes your point about the clear distinction between buy and on behalf of is made by Lord Justice Lloyd in paragraph 15.
Yes. Well, I endorse all of, I adopt all of that, my lord. These provisions are now contained, as I mentioned, in section 44 of the 2006 Act, which we have at Authorities Bundle 1, tab 20. 129, I'm told. And they're actually not that strict, in fact. Some commentators have expressed the view that these are perhaps more lax than they should be, but this is where we are, the current state of the legislation, and you'll see in section 44 that it's either by seal or, excuse me, two authorised signatories. Authorised signatories can be a director or secretary, or now, and this is where the commentary has been about it being a bit perhaps more lax than it should be, a director in the presence of a witness who attests the signature, and that's at 44.2b. Now, the appellants placed some reliance on a case after Hilmy, which concerned a different provision, which is the Northwood case. I probably should deal with that briefly. That's in Authorities Bundle, 2022 case, Authorities Bundle 3 at tab 88. 1856. And that concerned a rather different provision. It concerned a provision under the Housing Act 2004. So we've at last moved away from the 1993 Leasehold Reform Act. And in that case, the landlord had served a notice of possession and confirmatory certificates, which the tenant said were invalid because they were not signed by the landlord in accordance with section 44 of the 2006 Act. And the Court of Appeal held that the notice and certificate were valid under that different legislation. And they distinguished Hilmy in paragraph 15, which is on in the report on page 9 of the report at the top of the page. The contrast being, you'll see in paragraph 17 the reference to there that the statutes were different. Of course, the critical feature being that in the 1993 Act, the legislation distinguished between signed by a company and signed on behalf of a company. And the court referred to general agency principles over on page 11, bundle page 11, noting, they cite Lord Hoffman at 28 and cite him further at 29, where, paragraph 29, where they note that Lord Hoffman noted that there are statutes which exceptionally require a personal signature and exclude performance by an agent. And Hilmy found over the page on for Northwood case found over the page at page 12, paragraph 30, that Hilmy was such an exceptional, a statute of that kind of exceptional nature, because there was no equivalent wording in the Housing Act or the 2007 order that they were dealing with, and the court drew out the differences in language that's considered in Hilmy and the language they were considering. And obviously we say that section 53(1)b is just in that, exactly in that category for all the reasons that I've mentioned. Now,
although it's only over to, you've got Lord Justice Lloyd in agreement with that.
Yes, and quite. He said it in the passage I showed you a moment ago.
Well, you said it in two cases.
He said it below in St. Ermines as well. Yes, he did. And it's also worth bearing in mind in this debate that the modern law recognises that this shorthand of saying directors are agents of the company and companies can only act through agents can be misleading. Because, I mean, we've quoted in our main skeleton, and I probably should show you just briefly, Gower's Principles of Modern Company Law. The emphasis should be on modern there, but the Authorities Manual 5 at 154, where 3164, where I just want to quote one sentence at page 2 of this citation, where in paragraph 8004, if we just pick it up about 6-7 lines in, the editors say, where the board of the shareholders collectively act, they constitute the company, i.e. they act as the company, they are not its agents. And that is echoed by Lord Walker's analysis in the final appeal court in Hong Kong. And we have that actually in the Authorities Bundle 3 at tab 83, where he addresses this in our, for our purposes at page 33.
1775.
1775, where the whole discussion that has been lined on the side is obviously well worth the read, but in particular, if I could draw your attention to page 33 in the middle of the page in paragraph 64, where he notes that the directors alone are in the special position of deriving their authority not from other natural persons, but from the company's written constitution, that is, its memorandum and articles of association. And he does in this passage explain the errors in the older references to the board acting as agents. So far as section 531B is concerned, my lords, the respondent only needs to establish that there is a difference in law between signature by a company and signature on behalf of a company, to demonstrate that the company's participation is not an impediment to our construction. And the application of the subsection to companies that does not allow agents in on the basis that companies can only act through agents. That's wrong as a matter of law. Companies do execute, and they do execute documents themselves, and there's no in principle problem as the appellants contend. Now we're going to move to ground 2 with having dealt with that introductory issue. Ground 2, the appellants say the court should treat the mortgage document and indeed the amended defence as being signed by NIOC itself rather than by an agent on its behalf. Now, in the case of the 2019 mortgage, they make that on 3 bases. They say first that the UBAF case compels it. They say secondly that it fulfills the requirements of the equivalent of section 44 for foreign companies, which is contained in the regulations. And thirdly, they say this is the effect of section 74, subsections 3 and/or 4 of the Law of Property Act. It may be that subsection 3 isn't pursued, it wasn't addressed orally, and it obviously applies to individuals. So it may not be necessary to apply it to deal with 74.3, but I do need to address 74.4. And NIOC also says that some of those grounds apply to 2 other documents signed by Eversheds. They say the first argument, the UBAF argument, applies to the 2020 land certificate, taking all this from their skeleton argument. And they say that the first and second arguments, the UBAF and the Regulation 4 arguments, also apply to the amended defence. The references in their skeleton arguments are paragraph 36 at CB tab 6 at page 54, and also paragraph 38 sub 3. Now, dealing with the UBAF case first, that was a decision, it's in Authorities Bundle 4, tab 123. 2480. And this is a decision which you were taken to, which was under a different statute with different wording and a different legislative purpose. It was decided under the Section 6 of the Statute of Frauds Amendment Act, which is cited in the report at bundle page 6, 2485, at the foot of the page. You will see the citation from Lord Tennyson's Act, Section 6. And the appellants themselves say in their skeleton argument, NIOC's, this is NIOC's supplementary skeleton, paragraph 24, the reference is core bundle tab 25, page 341. Where yes, they say in paragraph 24 in the last lines, 3 lines, Section 6 of the 1928 Act is a different provision with different wording and a different policy objective. It does not assist the court in construing Section 53(1)(b). Now, it seems somewhat inconsistent to be asserting that the case compels the court to treat certain documents as satisfying 53(1)(b), and even perhaps less consistent for Mr. Thankey to say that this decision, as he did in his oral submissions, that this decision is binding on this court on the issue that's before it.
But it's not a question of construction of 53(1)(b) now, is it? It's a question of what's meant by a company signing.
It is. I particularly rely on the assertion that it's the agreement, that it's a different statute with different wording and a different legislative purpose. And of course, the question of the company signing is very pertinent to that. The Section 6 of the 1828 Act is about, as your lordships, my lady will have seen back on page 6 of the report, go back to Authorities Bundle 4, tab 123, page 6, 2485, through to the page. It's about representations as to character or credit for the purposes of obtaining credit, essentially. I've shorthanded, there are a few other subtleties included, but it provides that no action shall be brought unless the representation is in writing, signed by the party to be charged therewith. And the case came before the Court of Appeal at the interlocutory stage, the leave to serve out stage. You see that, well, you see it from the head note on the previous page 1 of this LVB 123. The leave had been set aside, leave to serve out had been set aside, among other grounds, on the basis that the Assistant Secretary's signature could not constitute signature of the company for the purposes of Section 6, so the protection of Section 6 applied. And the court held that the question, you find this on, if you go to page 8, bundle page 8 of the report, it's just beside letter C on that page. The court held that the question of the extent of Mr. Macheris's authority would have to go to trial, just beside letter C there. But for the specific purpose of Section 6, a duly authorized agent acting within the scope of their authority could suffice. And they found that on page 12, bundle page 12 of our report, foot of the page by letter H. Now, the wording and structure of the statute in issue in UBAF were very different from section 53. The legislative purpose of the two provisions is obviously different. This one is about when a company or individual is protected from action on a representation as to credit. It effectively affords the company a defense to a tort claim. So one can immediately see that different considerations are likely to apply as to when the company should or shouldn't be liable. But NIOC's main skeleton says that, notes that UBAF wasn't cited in Hilmy, but it then ambitiously says, well, if it had been, it would have changed the decision in Hilmy. Again, different statutes differently worded and different legislative policies, so we disagree that it would. Equally, it's also noticeable that UBAF was decided before the main changes in legislation affecting execution of documents by companies. Those were effected in 1989, the main changes.
Well, I wondered about that.
Yes.
I wonder whether, I mean, the specific point at H on page 724 is concerned with the notice under section 25 of the Landlord and Tenant Act.
Yes.
But if one takes it as a general proposition, it would be inconsistent with section 36A of the 1985 Companies Act
Yes.
and section 44 of the 2006 Act, wouldn't it?
It would, and it's noticeable, the date of the report is noticeable, 1984.
Yeah.
This judgment. And it was effectively decided as an authority issue without regard to any question of how a company would execute a document under legislation that specified how a company must legislate a document, and must execute a document. I mean, how UBAF would be decided today is now unclear, but I don't need to show it's wrong. It may be justifiable as a decision under that particular provision, but they may have some difficulty now, but given the legislation. But your Lordships, perhaps in this regard, will also recall Lord Hoffman's authoritative speech in Meridian Global on principles of agency. And it was cited in the Northwood case for rules of attribution and what acts count as the Companies Act. And perhaps we should just briefly look at that. It's in AB3 at 88 at page, excuse me, I've got the wrong reference there. It's AB3 at 79 at page 8.
This is Meridian.
This is Meridian. I'm sure the court is well familiar with this passage. It's quite often cited.
165.
1650. And the passage is the large paragraph in the middle. I'm not going to read all of it. Perhaps I'll just read the last 8 lines. This is on rules of attribution, picking it up from E. In such a case, the court must fashion a special rule of attribution for the particular substantive rule. This is always a matter of interpretation, given that it was intended to apply to a company. How was it intended to apply? Whose act or knowledge or state of mind was, for this purpose, he emphasizes, intended to count as the act, etc., of the company? One finds the answer to this question by applying the usual canons of interpretation, taking into account the language of the rule if it's a statute and its contents and policy. So the court may have to fashion a special rule for a particular statute, depending on its legislative purpose and context and so on. But you find the answer to the question applying the usual canons of interpretation, taking into account the language of the rule, its content and its policy, which we do in relation to section 53(1)(b).
Can I just understand that a bit better? Because are you saying we now need? You're not saying that section 44 isn't applicable as to in the law as we now have it? In other words, or do you say something different? So what rule governs 53(1)(b)? We've got a situation where it doesn't extend to agents. Do you say that in this day and age we should interpret it so that companies who sign in compliance with Section 44 can produce evidence for the purposes of 53(1)(b)? Or are you saying something different?
No, I am saying that, my lady. Companies can comply with 53(1)(b), and in order to do so, they would have to comply with the provisions of the Companies Act for what is the signature by a company. And
And just understanding that, so previously when there weren't such rules, that you've told us maybe
Yes.
they needed to use, effectively you said maybe they needed to use a deed.
or the corporate seal, which was a way historically of companies
Yeah.
executing documents, which was, as Lord Justice Lloyd observed, more often used in older times. What my submission is that the company under Section 53(1)(b) would have to comply with the prevailing law as to what constitutes signature by a company rather than signature on behalf of a company by an agent. So whatever the prevailing law is or was at the time, they would have to comply with it. And the prevailing law at the time of the mortgage deed was the 2006 Companies Act.
What's this law on specifying a specific rule of attribution based on the particular? That has nothing to do with it, does it then? Because you accept that if the prevailing law before 1985 was as set out in UEF, for example, then as to how a company signs, then that would be applied, wouldn't it?
Well, as to what prevailed pre-1985, in fact, I think the amendments were made in '89 and contained in the '85 Act. Well, it would be a matter of debating what constituted signature by a company at that time. I noticed it wasn't argued in UBAF that actually a company ought, if there were some provisions in the Companies Act, I don't want to get this wrong, there were some provisions in the Companies Act previously about companies executing contracts. There were provisions in the Companies Act about companies executing deeds, but
Not about executing
not
documents.
about executing documents. That came in.
That's the point that's made
Yes.
in Hilmy, isn't it?
Yes. In fact, I think the deeds may have been a common law before, rather than being statutory before that. Before in 1989 introduced statutory provisions about executing deeds.
Is that
and-
dealt with at all in UBAC?
I'm not.
I don't think it was. I think it was just a general discussion of agents.
Yes. So the argument doesn't appear to have been made in UBAF that actually the only way the company can do a document is by, at that time, the law would have been by deed or by seal, I would have thought. But it's whatever the prevailing law is. And yes, I mean, there are obviously the provisions of the 1948 Act about deeds. But that argument doesn't seem to have been made in UBAC.
Your point is the law changed. Whatever it was, whatever it may have been in 1984, changed as a result of the statute.
Well, it changed as a result of the statute, and as a matter of interpreting 53(1)(b), you have to interpret it as a company must execute. It has to be executed by a company, and that must be in accordance with the prevailing law. Now, I think some reliance was also placed on the Schechter case, it was only addressed very shortly in submissions. And I don't know if it may not be necessary to go into it in any depth, but this is a first-tier tax tribunal case where they were addressing two 2003 documents. The case is at AB4, tab 111. 2261. And there were two 2003 documents. One can see that from paragraph 9, which is on page 2, footer page 2 of the report. It goes on to paragraph 9, that goes over the page to page 3. There were two 2003 documents, a nominee agreement and a declaration of trust purportedly executed by a company, the Nexa, which was a Bahamian company. And the reasons why the signature of the director on the declaration of trust was found to be sufficient are in paragraphs 131 to 133 at page 29 to 30 of our report, bundle page 29 to 30. 2289. Now the reasons why the documents were found to be sufficient by Judge Alexander are somewhat convoluted. The tribunal cited the Overseas Companies Regulation we see in paragraph 130, this being a Bahamian company, as they were at the time. But then over the page at 131, because there was no evidence of Bahamian law, the court purported to apply English law. Now, query whether that was appropriate anyway, but under English law, to apply that default, but, and I may come to that under Regulation 4, but under English law, if you had defaulted to that, so as not adapted by the regulations at the time, it doesn't seem to have been cited, but a signature of one director would not have sufficed. They would have had to, at the time, 2003, have been under seal by two directors or a director and secretary. So on this point, the reasoning really just isn't very satisfactory at all. Because even if you defaulted to English law, it wouldn't have complied with the provisions of the time. Now, this UBAF argument, well, perhaps I'll deal with that after Regulation 4. Perhaps I'll turn to Regulation 4, unless if your lordships, my lady, are happy for me to. Regulation 4, the text we should look at is at AB Authorities Manual 1, tab 21, page 1. 131. Now, the one is looking here, obviously, at execution of documents, which is the title to 44, halfway down the page, and the regulations particularly relied on in relation to the 2019 mortgage, and that was signed by a person, Mr. Ragozar, and they would have to show, to be within this regulation, that Mr. Ragozar was a person who, in accordance with the territory in which NIOC is incorporated, Iran, was acting under the express or implied authority of NIOC. That's a necessary component of the case advanced here. But NIOC has never adduced evidence to establish that. And this court, as a result, is simply unable to say that this regulation applies. It certainly hasn't been shown to be satisfied. One can debate what the judge may or may not have found in his judgment about authority, but one thing that's very clear is he wasn't making any findings about the law of Iran in relation to authority to execute documents. So there's no evidential basis for this point before the court. Now, and they can't say, and they don't say, I mean, I know why they don't say it, that they can rely on a default assumption that the English law applies, because they don't satisfy the English law provision in section 44 either, because the mortgage document is not signed in accordance with the English section 44. And given that these are statute provisions which specifically apply on the one hand to English companies and the other hand to overseas companies, it would probably be inappropriate to apply a default assumption to English law in any event, because these provisions are specifically designed to apply to the two different categories of companies, but defaulting to English law is not argued. What Mr. Thankey did argue for the first time, or at least a hint of an argument for the first time orally, not in their skeleton, is that the mortgage deed might be compliant with the Companies Acts because NIOC, it was executed on behalf of NIOC as a deed. Now, if an overseas company wishes to execute a deed for the purposes of the Companies Act, it has to comply with the provisions of Regulation 4 relating to deeds, which you're not taken to, which are over the page at AB tab 21, page 2, at the provision 46. And we see there a document validly executed by an overseas company as a deed. It is validly executed by an overseas company as a deed, purposes of section 1(2)(b) of the 89 Act. That's the, as we know, is requirements for making a deed. And for the purposes of Northern Ireland, if and only if it's duly executed by the company and it's delivered as a deed. Now, so duly executed by the company takes you right back into section 44. And there is some authority on that. I can have it uploaded. It's a case called Arrow Game in 2016. We can have it uploaded, but this is a new point raised orally. So it takes you right back into the question of whether Mr. Ragozar was authorized under the laws of Iran. So it comes back to the same question. It isn't an answer, and that doesn't work for NIOC either.
Well, it'd be surprising if execution as a deed was more liberal than execution of a
yes.
document.
Yes.
And what you're really saying is it isn't, because it still has to be executed in the same way as a document under section 44, and it also has to be delivered as a deed. And there's obviously an issue about that in this context, because there's no evidence it was delivered as a deed.
Well, the mortgage document does say, it does purport to be executed as a deed.
Oh, well, yeah.
It does purport, but I think my point is that
It still has to be executed in the same way
according
as
to
a
the laws
document.
of Iran, yes, it still has to be executed as per 44, which says what it says. And so it isn't a workaround to say, because it was purported to be executed as a deed, that gets around the problem. It doesn't. And what in their skeleton, they ambitiously rely on what the judge found about the documents when he says executed by their attorneys, but he's not making any finding about Iranian law when he says that. I mean, it wasn't the point that was before him. And so far as the Companies Act is concerned, the mortgage was executed by an agent on behalf of NIOC. It wasn't executed by NIOC. That's the view of the Companies Act. And for the avoidance of doubt, it isn't an answer to the absence of Iranian law on authority for NIOC to say, well, you didn't take an authority point. The Regulation 4 argument is not responding to our respondent's notice. they got permission on this point before we filed our respondents notice. It's in support of an appeal ground 2, saying the judge got it wrong under section 53(1)(b) because you should treat the document as signed by NIOC. And section 53(1)(b) and its compliance was very much an issue below. You saw the pleadings where the point, the non-compliance was specifically put in issue. So if they were going to make a case that this was signature by NIOC, they should have brought along some Iranian law evidence to prove it. And they can't say, oh, the reason we haven't got Iranian law is because you didn't take a particular point. This is a point that they would have to plead and prove.
Am I right in thinking that section 44 and its equivalent were not relied on? They weren't relied on below. They weren't discussed. Certainly not in the judgment.
I'm told they were not discussed, my lady.
So there was a debate about whether agents could execute, but there wasn't this debate.
I think there wasn't this debate, my lady, no.
Was it also not raised, therefore? Was there nothing in the pleadings or the argument?
The regulation 4 does not appear anywhere, I think, in the pleadings or argument below.
So in other words, they didn't put it as part of their case below that even if they were wrong on the agency point,
This
there
is
was signature by the
by
company.
NIOC on the basis of regulation 4. They did not make that case below. Returning to section 74, which is another new argument from the appellants, which was not put below. I'll turn directly to, this only applies to the mortgage document because it's the mortgage document that was purportedly executed under a power of attorney, and it's a power of attorney provision. We should, let's first of all look at the provision itself at Authorities Bundle 1, tab 10. 83. Three obviously rates individuals, so I'll pass over that. Sub 4, where a corporation aggregate is authorised under a power of attorney or under any statute or other power to convey any interest in property in the name or on behalf of any other person, including another corporation, an officer appointed for that purpose by the board of directors, council, or other governing body of the corporation, by resolution or otherwise, may execute the deed or other instrument in the name of such other person, and where an instrument appears, etc. We don't need that bit. So it says where a corporation, that would have to be NTT, which is the beneficiary of the power of attorney, is authorised under a power of attorney to convey an interest in property on behalf of another person, NIOC. A person appointed for that purpose by the board by the governing body of NTT may execute the conveying instrument. Now, just 3 short points on this as to why it doesn't apply. First of all, the subsection doesn't appear to apply at all to declarations of trust because they don't involve the conveyance of an interest, but the creation of a new equitable interest. And you were shown the authorities by Mr. Thankey. He took you to the Rajoda case, Commissioner of State Revenue in Rajoda, and I think Transfer was the other case that Mr. Thankey mentioned. The Rajoda is in Australia's highest court. This is about grafting a new interest.
Just on that, we were told, I think, that there's a definition of conveyance and convey, which is not in the bundle, but is
Yes,
broad.
but even on that definition, which we've checked, even that wide definition of conveyance, it's not conveying an interest in property, it's creating a new equitable interest. See, conveying an interest in land is what 53(1)(a) is about. That's not what B is about. And so section 74(4) is directed at conveying an interest in property. You could have in a transfer of trust case, which we are not, you could have the conveyance of the legal estate would be within A, 53(1)(a), and might be arguably be within this section. But that's not the case we're dealing with. nor is it apparent what the relevant conveying instrument would be for a self-declaration case like ours. It's not apparent what the relevant conveying instrument would be. Now, secondly, my lord, my lady, if contrary to my analysis, it has any application at all, it directly raises the question of what was authorised under NIOC's power of attorney in favour of NTT. And the property interest we're concerned with, if this section applies, is whether the power of attorney authorised NTT to declare a trust over NIOC House. Now, the answer to that, as the court knows, we say is no, for reasons which I'll come to on the respondent's notice, but I won't digress into them now because I will have to deal with them then. So there's that point. And the third point, just before we leave it, is that if it otherwise applies, it requires proof that Mr. Ragozar was a person appointed by NTT, the attorney, that's an English company, NTT, the attorney, by its board of directors or council or other governing body of the corporation to execute the deed or other instrument. And so it also fails on that count, as they haven't shown they come within the section in that manner either. So that's section 74. I was going to move to ground 3, if I may. Ground 3 goes to the effect of non-compliance with the subsection 31B. NIOC on this ground, and both appellants, I think, can say they can rely on the alleged declaration of trust, even in the absence of signed writing, which complies with section 53(1)(b). Now, this ground fails on an entirely conventional view of the effect of non-compliance with section 53(1)(b), as indeed the judge found in paragraphs 201 to 213 of his judgment. So and I'll deal first with the conventional orthodox view. As your lordships and the lady knows, we've also in our respondent's notice challenged the conventional view, but I'll be quite short on that. It is, even if the court isn't attracted by those arguments, the cases are instructive in how to interpret the so-called conventional view, because they do show that the court should be very cautious indeed about giving any effect at all to a declaration of trust which does not comply with the subsection. So the conventional view is unenforceable but not void. If you start from first principles, I need to get my section out again. If you start from first principles, in construing the subsection, as we discussed yesterday, the legislative intention is as a safeguard against fraud. Now, the subsection is mandatory. The declaration must be proved in the way described. Mandatory language. And being mandatory, there has to be an effective sanction for non-compliance. Otherwise, the effectiveness of the subsection is undermined and it becomes meaningless. And if it must be proved in writing, one asks why it has any status or can be proved for any purpose unless and until the section is complied with. If it can't be proved, it's unenforceable for any purpose. And if the subsection is about evidencing the trust, as the cases say, then it is for NIOC to show why the court should create an exception to an apparently broad rule to allow non-compliant evidence to be admitted for their purpose, which is to defeat a creditor claim. Now, there are some narrow exceptions that have been recognised in the cases, which I'll come to, particularly Rochefoucauld and Bousted, that doctrine, which itself is justified probably on the basis that the court should not allow the statute of itself, a statute passed trust to prevent fraud to be used as an instrument of fraud,
Yeah.
and or on a constructive trust analysis. In that case, you'll recall that the Comtesse arranged for land titles to be bought by her manager to be held on trust for her, and he later tried to deny that he had bought the land on trust, and then tried to rely on Section 7 of the Statute of Frauds to say you can't give oral evidence of the trust, and that was not allowed. And conspicuously, it is NIOC's interpretation of the law in this area which would again turn the purpose of 53(1)(b) on its head and transform an anti-fraud provision into an instrument of fraud. They posit a situation where evidence of a non-compliant declaration of trust can be admitted contrary to the express wording of 53(1)(b), and the trust thereby enforced against a creditor. Now, the scope for fraud and abuse of this section in that situation is huge. If you consider a self-declaration case, settler can make or pretend to make an oral, unevidenced declaration of trust over their land, doesn't even need to tell the beneficiary. Wait and see if a creditor successfully pursues them, and if not, just retains the land, free of the trust. The beneficiary may not even know about this oral declaration, and can't in any event enforce the trust against them.
That's fraud by the trustee.
Yes, it is.
Which
It was
isn't
fraud by
what-
the settler.
Well, let's take a self-declaration case.
Yes.
It's fraud by that person.
By that person who is both settler and trustee
Is
in that
that
circumstance.
the evil against which the section was aimed?
Well, a very, very good question, my lord. Sorry, I didn't mean that. You know,
As opposed to every other question.
I didn't hear the way it came out. Yes. Can we rewind about 30 seconds? Yes. This is discussed in UDAN, and I'll get the reference in a moment, but effectively UDAN says that Lord Norfolk, who was responsible for putting the statute of frauds before the House of Lords, obviously had the creditor protection in mind, because he was concerned about secret trusts and so forth. And in fact, that has carried itself through to the original statute of frauds, which said in this regard, at Section 7, shall be void and utterly void and of no effect.
And no effect, yeah.
But what the courts then did was to water that down to an evidential requirement by court decisions. And then the void language was dropped in 53(1)(b). But my answer to that is really this, that just because the protection for creditors is watered down to an such as it is watered down to an evidential requirement and isn't a void provision, doesn't mean one should water it down further. So you don't even need to comply with that vis-a-vis creditors. The other way to look at it is some protection is better than none, so far as creditors are concerned. They may not have got the protection they might have wanted, but as UDAN discussed, the proponent of the bill did have creditor protection in mind. Now, I'm sure I have somewhere in mind.
to what
It's Lord Nottingham, sorry, I said Norfolk. Too many Shakespeare plays, sorry.
To
Lord
what
Nottingham.
extent is your point undermined, not just by the courts, as you say, watering it down to an evidential requirement, but also by what Gardner and Road did?
Yes. Well, I wonder what respect your lady is referring to. I think the way they dealt with creditor protection in that case was that the Vice-Chancellor directed a trial by jury on the question of whether the declaration was genuine.
Yes,
You may
but that's
remember.
still using parole evidence to establish that.
I know. We have issues with Gardner and Road. You will not be surprised to find out. And I probably should reserve our position on the correctness of Gardner and Rowe in case it ever becomes relevant. But the
It's, because it's a decision of the Lord Chancellor on appeal, it's of concurrent jurisdiction so far as this court is concerned. So it's binding.
well, it's statute of frauds decision, and as we know,
Well, yes, I suppose so. That's a little
yes.
bit difficult.
so I think it's not strictly binding, and it's of as much persuasive authority as the court wishes to give it.
Sorry, for my benefit, you said, and as we know, you're about to say, we know what? No,
What do we know?
it's
Oh.
statute of frauds, and therefore, as we know.
Well, sorry, as we know, I was about to cite Gray in the IOC
Right, yeah.
and say you can't draw a straight line, and you've got to be. It didn't say be careful about previous authorities, but it basically saying those were decided under the statute of frauds.
No, I follow that point. But I just want the point you were making was you were reserving your position on Gardner and Rowe, so that should this case go to the Supreme Court, you could say to the Supreme Court, Gardner and Rowe is wrongly decided,
Yes, that.
and they could overturn it, whereas we can't, or we shouldn't.
Well,
Is
that
that the
is-
point?
Yes, that's the point. That's the point. I'm not conceding that it's binding on this court for the reason that it's a statute of frauds case.
No, I understand the point. I'm
yes.
just trying to understand.
Yes. I was referring. I said Lord Norfolk, Lord Nottingham, of course. I misspoke. And the UDAN passage is at Authorities Bundle at 133, page 8. 2774.
Yeah.
2774, where it refers to the concerns about creditors. And it continues over to, from recollection, to the top of the following page, page 9. And of course, from the creditor's position, our interpretation would be, well, creditors didn't get as much protection as they might have wanted, but some protection is better than none, and there's no justification for watering even that protection, such protection as they may have, down. So just because it's imperfect doesn't mean frauds on creditors are irrelevant to the section. Turning to the authorities, my lords and my lady, many of the textbooks do not address this issue. There are many that set out the orthodox view, unenforceable but not void. But there isn't a lot of illuminating exploration of where the boundaries of that are. And incidentally, there's no English case law support that we can find for somehow limiting unenforceability to applying between beneficiary and trustee. And of course, if it's unenforceable between beneficiary and trustee, it begs the question of why it should be enforceable or have any legal effect against anyone else. We would say that third parties should be an a fortiori case, an even more obvious case. I mean, as Dr. Wilde says in his article, which we quoted in our skeleton, it's not a trust that outside parties would recognize, such as tax authorities. And one asks rhetorically, are they really saying that a tax authority could not pursue a settler's land in the example I gave earlier of the oral undisclosed trust?
One question I had is in the context of the insolvency legislation we're looking at, this isn't not accurate to say it's an attempt to enforce or not attempt to enforce against Crescent. It's more whether the words of section 423 apply.
I could, yes.
And your point about HMRC rather prompts that.
Mhm.
And the question might be, well, there's assets of value here,
Yeah.
and they appear to have some value to
Yes.
the putative trustee, unless and until the trust is enforceable against them. And if the trustee does something to remove that value, then you might think it's a somewhat surprising result if section 423 doesn't apply.
Well, yeah, I endorse all of that, my lady. Because one of the things that is slightly ignored in this debate is we aren't just dealing with section 53(1)(b), we're dealing with the interaction with section 423 of the Insolvency Act. And you actually see that. That's one of the reasons why those American authorities are so dangerous to go near, is because the American insolvency legislation, bankruptcy legislation is very, very different as well, and notoriously different. So there are other reasons why it's dangerous to look at that and give it any authority's guidance. But I'll perhaps come back to that shortly. But I mean, and just perhaps in response to your ladyship, the appellants in this case try to drag us into a semantic debate about what's enforcement. It's a labelling debate that they would want us to get all tied up in. But even if anyone's doing an enforcement analysis, you should not give enforcement an unnatural meaning. I mean, in our scenario, if we lose on this ground, then effect is being given to the trust against us. Effect is in some way being given to the trust against us if we lose. And you can call it enforcement, you can give it another label if you want, but that's what's happening. Well, I tell you what's happening is evidence of the trust is being admitted against us contrary to the wording of the section, even though the section has not been complied with. And the NIOC's view of the law also gives rise to legally inconsistent positions, where some actors are bound by the trust and some aren't. I mean, one could ask rhetorically why HMRC should be bound by the trust when the trustee and beneficiary are not. And of course, I mean, to state the obvious, it starts to mean that there's no effective sanction for non-compliance with the section. Because I don't know what the appellants think the sanction for non-compliance is, but it can't be an effective one if they can prove and rely on the trust in one of the key situations that's likely to be relevant, which is where a third party makes a claim against the settlor's assets. Not much of a sanction. Now, there's nothing in the wording of the section itself, 53(1)(b), nor anything in legal policy behind it to suggest that a non-compliant declaration of trust should nevertheless be given effect against a third-party creditor. Nor is there any case law which supports such a reading. And that brings me to Gardner and Rowe, which we have looked at. Perhaps I'll just deal with that before we break this morning. We've been there once before. It's at Authorities Bundle 2 at 50.
Yeah.
901. This is the Vice Chancellor's decision. The facts, I think I mentioned the facts yesterday to demonstrate that it was actually a transfer on trust case with the trustee giving the declaration. So I won't repeat the facts. I think the court's now familiar with them. And the declaration by the trustee was following the trustee's own bankruptcy. And the question before the Vice Chancellor was whether the bankruptcy of the trustee made any difference. And in a shortish judgment he found the declaration was a valid declaration within the statute of frauds, and that was upheld by the Lord Chancellor. So the obvious point to make here is that this is not a case of enforcement of a non-compliant declaration. It was a case where a compliant declaration was found. And of course, this ground 3 proceeds on the basis that there's no compliant signed writing. And as I mentioned a moment ago, we do have reservations about Gardner and Rowe. It's of course a statute of frauds case. It's not binding, but of course of as much persuasion as the court wishes to give it. We do have reservations about whether the potential fraud on creditors question was properly considered, but the Vice-Chancellor did direct an issue of fact on that question.
Yeah.
And it was a transfer on trust case. And if you had a self-declaration case where the risk of fraud is most egregious, there would be a question as to whether the settler had effectively divested themselves of the beneficial interest. I appreciate that the Chancellor's judgment helps them on that, but as I say, we do have reservations about it, and it may be justifiable, of course, on the facts as on a constructive trust analysis, because it may have been thought to be unconscionable that the trustees' creditors would have the benefit of the land. But those are our reservations. I was going to turn to Rochefoucauld and Bousted briefly, and perhaps that might be a good place to bring.
It's quite interesting that the Solicitor General argued the case, and he was very strenuously arguing that the court shouldn't give effect to the
Yes.
to the declaration on the basis that it would have amounted to using the statute of frauds to be used for the purposes of fraud, and that's what he puts. That's the argument at the top of page 3.
Yes. Yeah. I think if there's a justification there, it's the idea that a jury trial was of that issue of fact. Was there a genuine declaration of trust? Was directed, and the jury found
and then the jury found there was a genuine declaration.
and that seems to be how the issue of potential fraud on creditors was dealt with. That finding of fact was that actually it's not a fraud; it was a genuine trust. Was addressed in the case, but.
Well, there's similarly no challenge here to the declaration of trust, if it was one, under the mortgage deed, is there?
If there was one.
It's not suggested that as a fraud on creditors.
That's correct, but it does, that is correct, but these considerations may potentially affect the construction of the question of the section as a matter of principle.
But that was the concern in Gardner and Rowe, wasn't it? Not the fact that evidencing it later after bankruptcy had intervened was itself some fraud on creditors. It was the potential that the original declaration had been a fraud on creditors, and that was done away with. In our case, that doesn't arise at all.
In the case of the mortgage deed, no.
So the convenient moment
It is, Mark.
just after 10
Court rise.
Yeah, yeah. He likes to have yeah, yeah. But I just okay, so it's all we can between us do that. Yeah, refresh the thing as a secret from 1A. So,
Anyone that comes with it, put the tab in the description. Put the tab in the
do you want to just give it to me? I can try to get it down.
I can mark up the speaking.
Oh, sorry.
You can mark up the
Going old school, pre-open. So did Drake make that comment before she asked the question?
No, I think it's after. Sorry, sorry.
I can do it because I know what. Because it's really on the speaking of it.
Yeah, no, I get that. So should this be here? Is this the wording that you want to highlight?
Yeah, I just said it like that because you can see it.
Say again, sir.
You can see A, B, and C.
Oh, I see.
But plenty email.
This page.
No, not
Yes. Falk was waiting for you to talk about. Yeah. Nice thing with the US.
Yeah, that was very good.
I think Drake's gonna go hallelujah. Put hallelujah on.
You probably don't need this. Oh no, that is, oh no, they said. That's almost 2.2. No, so that would make sense.
Distinction. Yeah, well, that does not count.
It's less relevant.
Yeah, it's really well.
good, that's. They probably need one.
All rise.
My lord, my lady, I'd reached Rochefoucauld and Bousted,
Yes.
on which much ink has been spilt or spent.
Spilled.
It's at Authorities Bundle 4, tab 107.
Yeah.
I think I've covered the facts. I mean, they're well, 2206. They're very well known. So I won't go into that. The case is, this is a recognised exception to what is now 53(1)(b). It's most often explained by the commentators on a constructive trust analysis. Constructive trust falling outside this section. And that's legislated for in 53(2), as the court well knows, and or as an application of the principle that the court won't allow the statute of frauds to be used as an instrument of fraud, and that is specifically referenced by Lord Justice Lindley in the case at page 206, which is bundle Authorities Bundle 107 and 11.
There's a big passage at page 12, isn't it, where they accept the second point, which is that the statute can't be used as an instrument of fraud
Yes.
itself.
Yes, and so it's specifically referenced by Lord Justice Lindley in the case itself. It's analysed in the articles. UDAN deals with it. Those who are against the constructive trust analysis cite the fact that, I'm sure the court's aware, but just let me deal with it to square it off, that they cite the fact that Lord Justice Lindley called the trust an express trust when he went on to consider the statute of limitation defence, which is what happens on page 13 of the report. And there are writings debating whether the court was only classifying the trust as an express trust for limitation purposes. Now, it may not matter for our purposes, but we have included in fact, it is worth just drawing this to your Lordship's attention. We've included Bannister and Bannister in the Court of Appeal in 1948 at Authorities Bundle 1, tab 28, page 4. 324. We've included the Court of Appeal judgment here because it is a judgment in which, in the passage between letters C and down to E, where Rochefoucauld and Bousted is referenced, the Court of Appeal appears to be expressly approving the constructive trust analysis of
Sorry,
Rochefoucauld.
where are we, letter?
It references Rochefoucauld up on the left-hand side between E and F.
Yes.
And in the passage, so what the effect of the passage between C and E, perhaps we could just invite the court to read it, in our submission is that the court is there effectively endorsing the constructive trust analysis of Rochefoucauld. And Mr. Thankey refers to the swaddling article. I'm not going to go there, but that article in its introduction recognises that it's arguing against the grain when it says it's an express trust. It actually recognises that in the introduction to the article.
Yeah.
And he accepts that the dominant view is that it was in truth a constructive trust.
Yeah.
Interestingly, the author says he's not concerned to defend the correctness of the decision, which is of some interest.
I know you said you weren't going to go there, but it's just
Yes,
Just
it's
remind us where
at
it is.
EB5 140.
140.
I'm going to put Bannister away.
Yeah.
And in fact, I'm not going to come back to the Rochefoucauld itself unless the court wishes me to.
No.
If the swaddling article is, as I said, it's EB5 140. 2882. And it's in the very first paragraph that the author, 6-7 lines in, recognises the dominant view that it's a constructive trust case. And so it's arguing against the grain, this article. The point about not being concerned to defend the decision is in the middle of page 3. Yes. But defend the correctness of the decision, I should say. But the article is not saying you should disapply section 53(1)(b) in situations outside Rochefoucauld posted. That should be extended to any situation that could relevantly help the appellants in this case. And if, as he seems to be saying, no evidence should be allowed, then it should be inadmissible for all purposes, including against my clients, if there's no compliant evidence of the trust. But for present purposes, my lord, one can see that Rochefoucauld boasted. Let me summarise. It's a narrow exception to what was Section 7 of the Statute of Frauds. It's effectively a judicial disapplication of the section such that so that the section was not itself used as an instrument of fraud, and in circumstances which can have no application in our case here. It's exceptional, and it's not any kind of justification for an extension of the doctrine which would assist the appellants. My lord, two other authorities are cited here, which I'm happy to deal with not going there, but if your lordship and my ladyship wishes to go there, I will. There's the New Zealand case that you were addressed on, Mr. A and the Commissioners of the Inland Revenue. That was in Authorities 2, tab 62, page 1.
Yeah.
1256.
1256. That was a decision of Mr. Willey of the Taxation Authority, Review Authority. Again, it was a case in which the trust had been evidenced under the similar New Zealand statute, because he considers and looks at the writings that had been provided and found them sufficient. That's paragraphs 65 to 66. And then Dawson and Ellis was relied on. The AB1 tab 37, 587. Yeah. Which is it's a contract case. It's not about declarations of trust at all. I mean, perhaps we should look at it briefly, but the AB1 tab 37, the 1820 decision, where the court can rely on a council concession under a different statute of frauds provision, which is section 4. I mean, essentially the facts are in the highlighted passage. Ellis said he had an oral contract he's said to have had an oral contract to sell to the Duke of Norfolk. Maybe that's where the Duke of Norfolk came into my head a moment ago. And there was a subsequent written contract to sell to Dawson, but Ellis then conveys the land to the original purchaser, the Duke. And counsel for Mr. Dawson conceded that notwithstanding Section 4 of the Statute of Frauds, the oral sale to Mr. Dawson would take priority, as it was binding on Mr. Ellis's conscience. In the event, it was found there was no such contract, oral contract. But Section 4 is, of course, differently worded to what was Section 7 of the Act of the Statute of Fraud. It refers to no action being brought and so forth. It really tells us, this is not even a trust case, it tells us nothing about our section or declarations of trust. And indeed, if there had been an avoidance purpose, the conscience in question might have been rather different. Just a couple of points before moving on. I ought to address the line taken in some of the textbooks that say, the common line taken in some of the textbooks, that the trustee could, with a non-compliant trust, the trustee could choose to carry out the trust. Now, the trust don't cite authority on that, but it's obviously supported by a lot of, so the text, I misspoke, the texts don't cite authority on that, but it is supported by a number of the academic writers, and you can see how that could be justified. It's not the writers saying there's a compulsory effect to the trust. They say, but it could be justified on the basis that if the trustee claimed the property beneficially, then that would be a fraud, and one doesn't allow the statute to be used as an instrument of fraud. And you could also justify it on the basis that the property may be impressed with a constructive trust in any event in the trustee's hands. So it doesn't seem objectionable for the trustee to carry out the express trust.
You're talking there only about a transfer case then?
That would be a transfer case.
But what about a non-transfer case?
In a
The writing isn't just about transfer cases, the text you're referring to.
Yes.
They're not just talking about a transferee trust being entitled to perform the trust.
The question being, I'm accepting in a self-declaration case that the settlor trustee would be able to carry out his own trust. I'm going to give that a little bit of careful thought, if I may, and revert to your lordship.
Yeah, it does seem to me to raise a point fundamental to this appeal, which is not so much about enforceability between the time that the trust is created and there is writing, but what is there? What is there in terms of a trust? It's not invalid, according to the prevailing view. You're going to come to that, I know, but assuming that is right, it's not invalid. It's merely not enforceable in the sense that the court will not order won't find a trust without the relevant evidence. But unless and until there is such evidence, what is there? Where is the beneficial interest? And that's pretty important, isn't it, for Section 423?
Well, it may be important for 423, that's right. And there is, on the authorities, in a self-declaration case, I appreciate there's that statement, well actually, Gardner is a trustee case. It is not clear that the beneficial interest has already passed on the declaration in a self-declaration case. That's not clear from the authorities. And one can see the argument, that arguments may be made. It may, in a particular case, as you also rightly pointed out, become really quite an important question.
Well, there's lots of possibilities. I mean, I think I understand it to be common ground that the writing can be subsequent.
Yes.
And that there is authority in the bundle that can be even after proceedings have been commenced. So it can be by an answer in chancery or an affidavit, unlike Section 4.
There is a case. Nab and Nab said you could do it in a pleading.
Yeah.
Yes.
So all sorts of things could happen in the intervening period.
Yes.
The settlor or trustee could go bankrupt. Gardner, unless it's only confined to conveyance cases, transfer cases, that says the beneficial interest resides in the supposed beneficiary. There could be a charging order against the property. The supposed trustee could sell it. Now, take that example as an example that Mr. Thank you or Mr. Mumford came up with. what I think what they said was, if the trustee, perhaps surprisingly in that circumstance, then admits the trust in a piece of writing, then the beneficiary could go after both the trustee and the recipient, if they were party privy to the breach, to reclaim the trust property. What do you say about all of those different possibilities?
Well, in the sale scenario, so we have just so I'm clear, we have a situation where your trustee sells for full value,
Yes, it's in breach of trust.
but still in breach of trust.
You could posit both possibilities.
Well, yeah, well, if you have an undervalue situation, you've got the intervention of 423, of course, but the potential intervention.
Well, only if there's an insolvency.
Well, 423 applies outside.
Only if there's a creditor, sorry.
Yes. Well, there's a potential constructive trust analysis, which, if it's a transfer on trust case, the been transferred to the trustee, you can see a potential constructive trust analysis. You can see a potential proprietary estoppel analysis if the asserted beneficiary, a representation has been made to them that they would have this interest, and they have relied on that by investing in the property or expending on the property. So you can have that. So there may, I think I was discussing this with Professor Davis yesterday evening. The breach of trust question is, I think, as I understand it, quite unsettled and a matter of debate as to whether you could, if it was subsequently evidenced, you could then sue for a breach of trust that had happened allegedly in the meantime. That seems to be a much debated and unsettled question.
But it might be we have to answer that question in order to understand what is there in terms of beneficial interest and who holds it in this period.
But I'm not sure we need to decide that for the purposes of this appeal.
Well, it may, I'm not saying we do, but it may have a bearing on it.
No, I can see how all of these issues are relevant. I completely agree. But I'm not sure that's necessary, because what you have to decide is whether the trust can be proved for the purposes of this case. And I'm not sure whether the beneficial interest has already passed. One needs to decide that for purposes of this case. I mean, that could be quite an involved question, because I appreciate there are some allusions in the cases, but I don't see it as a clearly resolved question, particularly in self-declaration cases, that the beneficial interest has already passed to the beneficiary.
But what may matter is, what was the position immediately prior to the beneficial interest passing?
Mm-hmm.
That's what I'm getting at, I think, because it's that passing of the beneficial interest, if it was a passing of the beneficial interest by the transfer in this case, that is said to be a transaction that's an undervalue.
Yes.
So the question is, where was the beneficial interest immediately prior to that transaction? And it can be tested by all these questions about, well, could there be a claim for breach of trust by the beneficiary, even though it had not yet been evidenced in writing? Because you couldn't do that if the beneficiary, in inverted commas, did not have the beneficial interest, and then see how they could sue for breach of trust.
No,
And obviously, if the beneficial interest remains with the settled trustee on the self-declaration, then Section 423 comes into play, but not otherwise, potentially. And that's the real point, isn't it? I'm not sure you can necessarily escape at least addressing the point.
Well, I haven't come on
No,
with the authorities on that specific issue about the beneficial interest. I appreciate there is that reference that my Lord Justice Zacaroli pointed out yesterday by the Lord Chancellor in Judgement Road. That was a transfer on trust case. It wasn't a self-declaration case.
But was that part of the reason? That's one of the issues you're confident in.
Yes. Well, if you have a self-declaration case and you let me be clear about this. If you have no evidence that complies with section 53(1)(b, and you then transfer the interest to the beneficiary, then you have both purpose and transaction for purposes of section 423. You have avoidance purpose if that's one of your purposes, and you have a transaction because you transferred it to the beneficiary.
Is it an undervalue?
Well, the value going that way is your so-called moral obligation that Mr. Thankey was talking about.
Yeah, well, that's the crucial question, because if the beneficial interest is already vested in the beneficiary,
Well,
then is there an undervalue by transferring legal title?
Or do you say, well, even if the beneficial interest in some senses is with the beneficiary, it's certainly not, if you like, full and unencumbered, because the
yes.
for the obvious reason that the beneficiary can't actually exploit that.
Well, it's unenforceable by them. And then that
therefore
goes
there-
to,
Therefore, there might be an undervalue on that basis,
Yeah.
even if you could, in some senses, say that the beneficial interest is with the beneficiary, and say that in part because it seems to be common ground that if paper was produced within 53(1)(b, it would be effectively retrospective.
well, that's what the cases say.
So if they do, that suggests there's something there already or waiting to be,
Some sort of inchoate in
Yes.
beneficial interest.
but not something that can be fully
I
exploited.
think your
That-
ladyship
that
may
was
be
one way of
describing,
looking at it.
sorry, I do apologise, I didn't mean to interrupt.
No.
What we may be describing is some kind of contingent beneficial interest, which is contingent on the satisfaction of the section.
Well, that brings, in a sense, that's sticking another label on the point, which doesn't necessarily provide us with the answer.
Well, let's think of how I would naturally have analysed this situation would be, I mean, Mr. Thankey says there's a moral obligation in this unenforceable trust. Now, most moral obligations in law are unenforceable and ineffective, as we know. There are specific situations where the court will, and there are narrow situations, like constructive trusts, where the court will actually give effect to some obligation of conscience.
Yeah.
Now, but if you're not in one of those, then moral obligations are unenforceable and ineffective generally in law. And if in the 423 analysis, even if this unenforceable moral obligation of conscience is capable of being taken into account in the consideration moving one way for value purposes, it must be vanishingly unlikely that it will be consideration which prevents the transaction being a transaction at an undervalue.
Yeah, I mean, one way of looking at this is to say 423 is all about value.
Well, it says it's about consideration.
And if I was a beneficiary under a moral trust of land that had no writing, I'm hardly going to get a bank to lend me money on the strength of that asset, am I?
No, well, the bank won't
So
recognise it.
that's making the value point.
Yes, I mean the most recent 423 authority, I think we have it in the bundles. I think it was inserted there for the breadth of what a transaction means, or an arrangement means. Is the El Hosseini case. Your ladyship may have been alluding to it the other day.
I was.
Yes,
Is it in the bundle?
It's Authorities Bundle 3 at tab 68. 1420.
Oh, thank you.
Tab 60. Sorry, it's
Yes, tab 68.
tab 68, and yes,
This is
Authorities Bundle 3.
Supreme Court in,
It's the Supreme Court in Al-Husseini. This was the case about whether it made a difference that what had happened was you alienated the company's assets rather than your own assets. And I mean, you can see from the head note, it's about what consideration. That's what the section passes. That's what the section addresses, section 423. So if you analyze it from a 423 perspective, what's the consideration? It's an unenforceable trust obligation. An obligation under an unenforceable trust.
obligation under an
Well, it isn't an obligation, but Lord Millett, this is why it's interesting to look at the invalidity argument, because Lord Millett obviously says enforceability is a key to the nature of a trust, and if you haven't got enforceability, you haven't got a trust. That's Armitage and Nurse. So the idea that this unenforceable, unevidenced obligation, or not properly evidenced obligation, could be sufficient consideration against the transfer of very valuable property for value purposes, in our submission, it just must be wrong.
Just test it this way, and I think value has to be addressed from the perspective of the company. It's value given and value received by the company, I think.
Yes.
Well, by the
Are we talking about this case or the
sorry, section 43.
Yes, yes.
Just one's looking at the perspective of the company.
Yes.
The beneficiary can bring proceedings to enforce the trust. They may be struck out if there's no evidence, and there will be evidence, but if the trustee admits in its defence the trust, then we know that's sufficient writing. So all that has to happen in order to perfect the beneficial interest, in a case if you say it's contingent, it ceases to be contingent merely by the trustee admitting that there was a trust.
Well, where I would dissent from that somewhat is the use of merely, because it's a very important step under section 53(1)(b). It's key. It is the step under 53(1)(b). So it's not a case of a trustee merely doing something. It's a fundamental change in the relationship.
Yeah, but I think when my lord says merely, that's by reference to the defence. So all you've got to do, I mean, it may be a very big step, but it's a question of what's required evidentially. And if all that's required evidentially is an admission in the defence, then so if the trustee and the beneficiary are agreed between themselves that there is a trust, and in some way or other, that's, I mean, all that's required is that that's reflected somewhere in writing, isn't it?
Or signed by the appropriate.
Signed by the settlor or the trustee.
Yes, I think the reason I bristle at all that's required is that section 53(1)(b) is the protection in this circumstance against fraud and so forth. And it is regarded as a key and a fundamental step to be done by someone. That's the whole point of the section, the subsection. Ground 3
the difficulty with all of this is, I don't know, maybe it isn't, but I understand that argument in circumstances where if NIOC and the fund suddenly popped up as it were out of nowhere and said, oh well, actually there's been a transfer. The fund is the beneficial owner of the property, and there's nothing in writing. then I can understand all of that, because you then say, well, this is just a fraud, or it's certainly Section 423 territory. But what we know is that historically they were all proceeding, albeit mistakenly, on the assumption that the fund was the beneficial owner of the property.
Well,
Then they discover that they haven't actually been, doesn't actually have legal personality, so they clothe it with legal personality.
well, no, sorry to dissent, my lord, but they didn't discover that they didn't have legal personality. They found the appellant's case was that they'd had legal personality since 2001. They only found out they didn't have legal personality when the judge delivered his judgment and said, actually, you only had legal personality in 2019. So that wasn't a fact discoverable by them at all until the judge delivered his judgment. Their case was legal personality in 2001. There's that point, but
But the point I'm driving at is a
Yes.
slightly different point,
Yes.
which is that at a time when no issue about defrauding creditors, if I put it in colloquial terms, had arisen at all.
yes,
So at a much earlier point in time, they were both proceeding on the basis that the fund was the beneficial, had the beneficial interest in the property.
yes.
And that's part of the background.
I agree, and I'll come to this when we deal with intention as
And
well. Yes.
So at a later stage, steps are then taken to perfect the trust because there's nothing in writing.
Well, they're not deliberately in any sense taken to perfect the trust in the mortgage documents, because that's the intention case. And if they, there were some findings, obiter findings about earlier documents that the judge made, which of course are obiter because there was no legal personality. And what the appellants have to show is declaration of trust in those documents. It's either those documents or nothing.
Oh, I understand that point.
Or there's a weak case made on the amended defence, but it's those documents or nothing. So it's not a case of them deliberately evidencing their trust. They weren't aware in the foggiest they didn't have legal personality in 2019. The last suggestion there was any issue on the appellant side was a document I saw years before that, and they took steps to, they thought, resolve it. There is that, but if you, what's happened on our facts is you have a non-compliant, if we're right on grounds 1 and 2, we have a non-compliant trust, non-compliant with 53(1)(b), and they then transfer the property to the fund.
With the judge found the requisite.
With the intention, which is, my next point is, that your lordship rightly, actually it's worth looking at the judgment on this, it's quite important. The purpose he deals with at CB 15-204. The passage is 214 onwards, I'm sure the court is familiar with them, but the key point is that he considers the evidence and he takes into account at paragraph 219 on page CB 15-205, he takes into account the understanding, the long-standing understanding of the beneficial ownership in NIOC House in the third line. So he takes that into account, but still finds they had the purpose. So he's taken full account of their case that actually all along they believed there was a beneficial ownership, and he still finds they had the purpose because of, and it's a point that comes home vividly from the discussion at the consequentials hearing on costs, because the judge effectively said to Malone and friends, well, instead, if you thought you had this interest, instead of coming to court and arguing for your interest, you transferred it away. And it came up into sharp focus in the indemnity costs application and so on. that's what we're dealing with. We're dealing with an unevidenced trust. Well, in fact, we're dealing with if they're not declarations of trust, on my respondents' notice, they're not declarations at all. They're not declarations of trust. But if I'm wrong about that, and they are just non-compliant with the Act, they then have a non-compliant trust, and they then transfer. So you've got your transaction for purposes of 423 to the alleged beneficiary, and you get into the debate. Then is what consideration is moving either way for Section 423, and in one way is moving this extremely valuable property of Victoria, and the other way is an unenforceable, I hesitate to describe it as obligation, because it's by its nature, obligations tend to be enforceable, but of course one talks about moral obligations and so forth. And in our submission, that can't possibly be sufficient.
So the question of value of consideration being given and being received was dealt with by the judge.
Yes, he
Albeit short.
he deals with it fairly shortly.
Is it 213?
That's a conclusion at the end of 213.
Yes,
Yeah.
Yes, I mean, it's arguable that it's not sufficiently nuanced, because he simply says the beneficial ownership stays with NIOC. Whereas we've been discussing whether, at least in some senses,
It might.
it might be described, this the contingency, or however you describe it. He just says NIOC was the beneficial owner,
Yes, I see that.
which is as if there wasn't a trust at all, which is not quite what the conventional view.
Can I give some further thought to that analysis that my Lord Justice Zacaroli has put? Yes, sorry, I'm also being directed to 224 on page 206. It was not for money or anything which is monetary value.
That's the same point, isn't it? Because it was subject to it was not subject to a trust.
Yes. Well, if this yes, it's put slightly more carefully in this paragraph. If I could, I may revert to this question. It's obviously a question of some significance. I mean, the other thing I can point out, of course, is that if we're right about no intention in the mortgage documents, then there's no trust at all, because for obvious reasons. Now, I'm just wondering, I mean, one thought that's occurring to me is we've talked about the Inland Revenue, which is often quite a nice test of getting a very objective creditor. You know, or if it had been a tax authority creditor, I mean, is one really saying in these circumstances that the tax authority could not have recourse to the beneficial interest because of an unevidenced trust. Because the company on the face of it has removed a valuable asset which might otherwise have become available for enforcement.
Well, I think
one way of one way of testing this might be, let's say, the revenue debtor, which is the would-be trustee, actually becomes insolvent because of a revenue debt before any piece of writing is produced.
Yes.
The trustee in bankruptcy or liquidator is hardly going to think it's in the interests of creditors to produce a piece of paper that confirms the trust.
No. It's, well, the paper itself might be the transaction at an underlying.
Well, I think that may be difficult. You don't,
Well,
on the facts of this case, you may not need to go there.
No,
because
I
you've
know.
got an
I
actual
understand that might.
But I mean,
Not
just
immediately
coming
easy.
back to the position of the revenue,
Yeah.
you might think that, because we've got profits of rent all through the life of this, so the revenue has got an interest in, I'm not going to talk about the facts of this case because I know that tax is discussed in the papers, but
Yes.
in principle, you might think that the revenue would say, well, from the point of view of the trustee, you're entitled to keep the income for so long as you haven't produced evidence that would allow the beneficiary to say, no, you can't keep the income. And so why shouldn't we, the revenue, tax you, the trustee?
Yes. But why should we, the revenue, pay any regard to this trust whatsoever? Which is an unenforceable trust. It would be staggering if they gave it any validity for any purpose.
Well, as I said, for so long as there's no piece of paper, the trustee can actually keep the income.
Yeah.
No one can stop them doing that.
Well, exactly.
It would be astonishing if the revenue couldn't tax.
Yes. And they can keep the property because there's no enforceable obligation against them from the beneficiaries.
It may be that if paper is produced, then they need to backdate the handing over of the income, but that's a different point.
Yes. And if the, well, yeah, okay. Sorry. Thank you. Now, I think subject to I wonder if another way to analyze this is that unless the appellants create an exception to section 53(1)(b), which currently does not exist, their alleged trust, if it's non-compliant, can't be proved for any purpose and can't therefore be proved for any purpose of saying we have a beneficial interest. My lord, my lady, just to conclude on this aspect of ground 3, I'll be very brief on the US authorities, which were cited. I mean, these were supplied to us on Sunday, so they obviously were a very late reliance on them. But I'll be very quick on these. The court obviously should exercise very considerable caution about that material. It's well known that the United States has a very different legal tradition, unlike perhaps Australia or New Zealand. And they have quite a number of states, obviously, and the scope for divergence is huge, and it's very difficult to cover each jurisdiction in the USA, and there's obviously only limited standardization. So one has to bear that very firmly in mind. The US cases and commentaries, they concern different states' statutes of frauds, themselves descended from the 1677 Act. They are language different from the 1677 Act and indeed different from one another. They say descended from, they say borrowed from the Acts. There's certainly, one has to be extremely cautious given the levels into the steps. We are removed from that. I mean, one of the Scotland Asher Authority says there's an immense body of case law. You can't obviously give justice to inciting two cases. And there's the point I made a moment ago, that the US bankruptcy law is very different indeed, and we're concerned with the situation of how that interacts with the so-called statutes of fraud that they have. And I also draw attention to what Scotland Asher say at AB 1774, which seems to, in fact, might be perhaps worth turning that up. AB 1773 is the immense body of case law reference in the right-hand column in the middle. Over the page at 1774, and this is very encouraging, on the right-hand column, first main paragraph, the result is that the courts have developed certain forms of expression for use in reaching whatever result they want to reach, based on policy considerations often left unexpressed. Quite, yes, when, that was rather my reaction when I read it. Whenever they want to give relief, notwithstanding the statute, they emphasise the hardship that would result from its application, denounce the party who relies on the statute, speak of fraud and say that the purpose of the statute was to prevent rather than promote fraud. When they choose not to uphold the transaction, they shift to the legislature the blame for any hardship. So it doesn't look like the application has been consistent or indeed necessarily principled. And yeah, I probably don't need to say much more about that.
No, I mean, the next paragraph slightly tempers the point, doesn't it, by saying that whilst that might have been thought to lead to chaos, it hasn't in fact, because there's a sort of general boundary as to, there's a boundary as to what the general nature is.
Yes.
I'm not sure that necessarily helps us.
No, and this is not a sound basis to approach the issue from the point of view of the Wealth Property Act, which isn't even being dealt with. So with that, my lords, I was going to move to our respondent's notice. Oh, actually, sorry, I should mention the challenge, given it's in the context of ground 3, and this is the respondent's notice, the challenge to the conventional view of validity. Obviously, we don't need to succeed on that, we would suggest. My Lord Justice Zacaroli has perhaps raised a question on that. The argument, it's informative because even if you don't accept ground 3 in full, it does show that a number of very eminent judges have instinctively regarded declarations of trust of land which are not evidenced in writing as being failed or invalid trusts. That, at a minimum, shows you that we're not to be particularly cautious about according them any effect. Now, I'm not going to, because of time and because I appreciate that one is going to some degree against the conventional view. I'm not going to spend a lot of time on this. The argument is made in our written argument. The argument is essentially, the invalidity argument, it's essentially that the wording and purpose of the statute support the conclusion that invalidity should result. The court isn't bound by pre-1925 authorities, and the existing authorities are sparse and not compelling. Your Lordship, my lady, has the written argument. I'm not going to dwell on it, but I would draw attention to the fact that there are these cases which call this issue into question. The Hodgson and Marks, which is at Authority 2, Bundle 260. 1197. This is the case which everyone seems to think they know this case, and then you go back to it and you realise you didn't quite remember it correctly.
Yeah.
It gets referred to a lot in very very authoritative terms. This is the case where the P transferred her house to the lodger, and there was an oral agreement that the lodger held it for the plaintiff, and the lodger sells the house, and the case was decided on the basis that the plaintiff had an interest under a resulting trust based on implied intention, which was protected by her actual occupation of the land. And Lord Justice Russell's judgment, with which others agreed, if we can look at that briefly at page 42 of the report. One sees just the first main paragraph. He says this: I return next to the question of whether section 53(1) of the Act prevents the assertion by the plaintiff of her entitlement to the house. Let me first assume that, contrary to the view expressed by the judge, Mr. Marks is not debarred from relying upon the section, and the express oral arrangement or declaration of trust between the plaintiff and Mr. Evans found by the judge was not effective as such. Nevertheless, the evidence is clear that the transfer was not intended to operate as a gift, and in those circumstances I don't see why there was not a resulting trust of the beneficial interest, etc. It was argued that a resulting trust is based on implied intention, and that where there is an express trust for the transferor intended and declared, albeit ineffectively, there is no room for such an invocation. I do not accept that. If an attempted express trust fails, that seems to me just the occasion for the implication of a resulting trust, whether the failure be due to uncertainty or perpetuity or lack of form. So if an attempted express trust failed under the Act, there was room for a resulting trust. So the court there seems to proceed on the basis that a non-compliant declaration of trust of land failed because of the section. Now, you can argue it's not logically impossible for an unenforceable express trust and a resulting trust to coexist, but it does give rise to an awful lot of unresolved conceptual and practical difficulties in the coexistence, not least of which is what happens if the express trust is rendered enforceable by some evidence, or if the willing trustee carries out the trust, which are all unresolved questions. So I draw attention to that. I also draw attention to Parker and the FCA, a very recent decision, which is at Authorities Bundle 3 at 92. 1983. Where the Court of Appeal, sitting on a compensation, a POCO matter, the Court of Appeal again seems to have regarded the declaration of trust over land as void under 53(1)(b). I mean, in this case, the question of beneficial ownership arose under the Proceeds of Crime Act, involving a fraudster who procured that victims invest in property investment opportunities. And it's of interest for what Lady Justice Andrews says at paragraph 71 to 72, which is at page 11, 1993, and the foot of the page, where she says, I won't read the whole thing, but she is saying a few lines from the bottom of the page, and if express trust is operative, then of course there's no room for a constructive trust. So constructive, she's saying in this passage, 71-72, that when a declaration of trust fails under 53(1)(b), a constructive trust can arise, and the two cannot coexist. And she follows through in paragraph 73 to 74 over the page. Whenever the court is ready, she follows that through to citing section 53 sub 2, which takes constructive trust, of course, out of section 53. And that's the finding that she makes when we get to page 16 of the report in paragraph 101, that there was a constructive trust applied over the relevant land. So the two can't coexist, and the court appears to be treating a non-compliant trust as a failed trust. And the other cases that we've cited they're not ratios, but this is Gissing and Gissing, Lloyds and Rossett, Armitage and Nurse that we've cited in that skeleton. And you have eminent judges, Lord Diplock, Lord Bridge, and Lord Justice Millett, as was, using expressions in Gissing and Gissing, declaration of trust, if it's not in writing, can only take effect as a resulting implied or constructive trust. The references are, I'll give the reference to that. It's Authorities Bundle 2, tab 52, page 20. That's Lord Diplock. And then in Lloyds and Rossett, you have Lord Bridge referring to the section as making a declaration ineffective at Authorities Bundle 3, tab 74, page 129. And then in Armitage and Nurse, you have Lord Justice Millett opining that there was an irreducible core of obligations. Perhaps you should look at that one. It's Authorities Bundle 1, tab 25, page 13.
206.
206. Armitage and Nurse, the
Tab 25.
tab 25, Authorities Bundle 1, tab 25, and the opinion in this respect he gives is at page 13 of our report, foot of the page, at letter, just above letter H. Accept the submission made by Paula that there is an irreducible core of obligations owed by the trustee to the beneficiaries and enforceable by them, which is fundamental to the concept of a trust. If the beneficiaries have no rights enforceable against the trustee, there are no trusts. Now, he's describing a situation which indisputably, we say, arises under section 53(1)(b) if you haven't complied with it, that the beneficiary has no rights enforceable against the trustee. That's what the cases say. And the fund and the skeleton say that the Lord Justice here is not distinguishing between rights and the ability to force them, but actually he refers to both the core of obligations and the ability to enforce them. He refers to both. And he seems to have had both very much in mind when he says that that if the beneficiaries have no rights which are enforceable, you have no trust. My lords, my lady, I was going to turn to the next respondent's notice point, which is the question of intention. And I'll just make a start before the break, if I may. In addressing this question, it's obviously important to have in mind that the judge found no legal personality till the 25th of September 2019. And that was coincidentally the date when the mortgage was executed. The judge noted the coincidence, saying remarkably that was the same date. That's in paragraph 185 of his judgment. So those matters were not factually connected. And since the fund had no legal personality before then, the judge also recognised correctly that he does this at paragraph 185, that it was for NIOC to point to a declaration of trust on or after that date. It would not be sufficient to find written evidence of a previous declaration of trust because there wasn't one. So our point here, my lords, is that the judge erred in law. Not in fact, the judge erred in law in his construction of the mortgage documents in their proper context against the relevant background that he found. And Mr. Mumford tried to characterise that this as an appeal of fact. It's not right. What we say is objectively construed, excuse me, in their proper context. There was no intention to declare a trust by those documents. And the proper construction of a written document in its context under English law remains a question of law. We've included Thorner and Major. It oughtn't to be controversial, I suggest, but we've included Thorner and Major in the House of Lords at Authorities Bundle 4, tab 121, page 25. 2170. 2470, beg your pardon. And it's just for what Lord Neuberger says at paragraph 82 on page 25, where he confirms a long-standing rule in relation to contracts.
Yeah.
The interpretation of a purely written contract is a matter of law and depends on a relatively objective contextual assessment. Almost always excludes evidence of the parties' subjective understandings, etc. There is authority that also applies to unilateral documents, such as wills. It's a case called Marley and Rawlings. We can put it in if the court wishes. It ought to be uncontroversial. So we're not challenging the judge's findings of fact so far as they concern the relevant background to the mortgage documents. We are accepting those findings of fact. And we are asking the court to construe afresh the mortgage documents against the facts found by the judge. And that's an issue of law. Now, and what we say, perhaps I can encapsulate it in this way, having made those findings and deployed them for other purposes in the judgment, the learned judge, when he came to construing the mortgage documents, in our submission, failed to take into account the relevance or consequences of a number of important factual findings he had made elsewhere, and which were, for this purpose, extremely important context. But instead, he focused almost exclusively on the words of the mortgage documents. So it was, in our submission, effectively an a-contextual construction by the learned judge. Now, it's an objective exercise. Contracts and unilateral documents are similar in that respect. But of course, the body of materials you'll be looking at in a declaration of trust case will to some extent be different. In a contract case, you're looking at what passed between the parties. In an alleged declaration of trust case, you're looking for the settlor's intention as outwardly expressed in their words and conduct. I'll come to the cases on this. And there isn't, of course, a contractual counterparty. And in a self-declaration case, there isn't even a trustee in order to examine communications with the trustee. The point, if we go briefly to Underhill and Hayton, just on the external manifestation point, it's in Authorities Bundle 5 at tab 158. 3198.
Tab 5.
And I'm going to go to page 3 of this extract. And perhaps I could just, it's paragraph 10.2, I'll just...
Should we read that to ourselves?
Yes, and it's particularly the words about externally manifested somehow, by saying something to someone else or writing and putting them down in a form that's discoverable by others later. I was going to go to Ong and Ping on the test, and
We're going to do that at 2 o'clock.
better do it at 2 o'clock. If I could perhaps just answer a ladyship's query about Ong and Ping yesterday before we break, which about the apparent conundrum of trying to revoke the trust by cancelling it, but finding that constitutes evidence for purposes of this section. I think the correct analysis is, and this may mean that the text, the writer I was citing wasn't entirely, had used somewhat lax language, is that a declaration of trust by its nature has to be irrevocable, otherwise it's not a trust, a declaration of trust. And if it's a genuine and valid declaration, even if it's oral, it has to be irrevocable. So if you have a valid declaration of trust that's been made, it's irrevocable. So of course, if you try to revoke it in writing, yes, that could be writing for the purposes of this section. So it does. The analysis does make sense. But perhaps that's a good point to break, Michael.
2 o'clock.
All right.